Hey everyone, welcome back for another deep dive.
Yes.
Today we're going to be looking at the legal side of OSHA inspections.
Right.
And specifically, we're going to be looking at Chapter 15 of OSHA's Field Operations Manual.
Okay.
And this is a really important chapter for safety and risk management professionals
It is.
to understand how and when OSHA uses its authority to gather information during inspections.
That's right. This chapter really gives you a look at how OSHA uses its legal authority.
Yeah, so let's imagine you're at your facility and an OSHA inspector shows up.
Mm-hmm.
Everything seems routine at first, but then they start asking for specific documents.
Right.
Or they want to interview certain employees.
Yeah.
Have you ever wondered what legal authority they have to make those requests?
Yeah.
And what happens if an employer pushes back?
That's where it gets interesting because OSHA has a couple of powerful tools they use.
Okay.
And one of the most common is an administrative subpoena.
So subpoenas. So that sounds serious.
It can be.
Sounds like a legal showdown.
Not necessarily, but subpoenas definitely carry some weight.
Okay.
And it's important to understand the two main types that OSHA uses.
Okay.
The first is a subpoena ducis tecum,
Okay.
which basically means bring me these documents.
But what kind of documents are we talking about here? When you say documents?
The manual is very clear that employers are not required to create any new documents
Okay.
to comply with a subpoena.
Gotcha.
They're usually after existing records,
Okay.
like injury and illness logs,
Right.
those OSHA 300 and 301 forms. They might also request details about your safety programs,
Mm-hmm.
things like hazard communication,
Okay.
lockout, tagout procedures,
Oh, yeah.
or even training records.
Well, that makes sense because they're looking for evidence that you have the proper safety measures in place.
Right.
But what about talking to employees?
Yeah.
Is that where the other type of subpoena comes in?
You got it.
Okay.
The second type is called a subpoena ad testificandum, and that one is all about compelling witness testimony.
So if OSHA wants to interview a specific employee about a safety incident or a potential hazard,
Right.
they can use this type of subpoena
Yes.
to make sure that employee shows up and talks.
Precisely.
Wow. Okay, so this is serious stuff.
It is.
These are legal orders,
They are.
and an employer might not be thrilled about it,
Right.
but ignoring them can have serious consequences.
Yes.
Okay, so let's say an employer decides to just say, no,
Mhm.
I'm not handing over the documents,
Right.
or I'm not allowing these employee interviews.
Yeah.
What happens then?
Well, usually the OSHA representative will start by explaining why the information is necessary for their investigation
Yeah.
and what the legal consequences of noncompliance could be. But if the employer just digs in their heels, OSHA can pursue legal action
Oh.
to enforce the subpoena.
So then there's this whole legal process that unfolds.
Absolutely.
Okay, wow. So this whole subpoena thing is pretty serious business. I'm curious about the authority behind these subpoenas.
Mm-hmm.
Is it just any OSHA inspector who can just issue them?
That's a good question. And it's important to understand that the authority to issue these subpoenas
Yeah.
is carefully delegated
Okay.
within OSHA.
Okay.
In most routine situations, it's the area director who's calling the shots.
Okay.
They handle the requests for documents or basic employee interviews.
So it's not like every inspector just has a pad of subpoenas
Exactly.
that they're handing out.
Okay, good. But there are times when even the area director's authority isn't enough.
Okay.
For example, if they need to compel testimony from a witness who's being uncooperative,
Yeah.
or if they're trying to obtain specific medical records that require a medical access order,
Mhm.
things get bumped up to the regional administrator.
Okay, so there's like a higher level.
There is.
Okay.
The regional administrator steps in when things get more complicated,
Gotcha.
or when they need to flex a little extra legal muscle.
Okay.
They also handle requests for physical evidence.
Okay, so the regional administrator is like the big boss
They are.
of subpoenas.
Yes.
Got it. Okay, so we've got these two main types of subpoenas.
Right.
We know that the area director usually handles things,
Mm-hmm.
but sometimes they call in the regional administrator.
Correct.
But let's get down to the nitty-gritty.
Uh-huh.
What does a subpoena actually look like?
Well, OSHA actually uses models for their subpoenas,
Okay.
which helps ensure consistency and clarity,
Mm,
but they might tweak the language a bit depending on the case.
okay.
The most important thing is that the subpoena spells out exactly what information
Yeah.
or testimony they're looking for.
Okay.
It has to be very clear and specific.
So, no, just bring me everything requests.
Oh, no, absolutely not.
Okay, good.
The requests have to be relevant to the investigation at hand.
All right, so specificity is key.
It is.
But what about deadlines?
Yeah.
Let's say OSHA subpoenas a company's training records.
Mm-hmm.
How long do they have to produce those?
Well, the manual's pretty clear about those timelines, too.
Okay.
If the subpoena is for those must-have records, like the injury and illness logs we talked about, you usually have 3 days from the time you receive the subpoena to provide them.
Okay.
But for other types of documents, like safety programs, details, or incident reports, you typically get 5 working days.
So they do have a little bit of time.
They do.
Okay.
But OSHA is serious about getting the information that they need
to complete their investigations.
Direct.
All right, so subpoenas are all about getting information.
Right.
But what about when OSHA needs to get inside a workplace and the employer is not allowing them to come in?
Yeah.
What happens then?
Well, that's where the warrant process comes into play.
Okay.
If an employer refuses entry,
right,
or if OSHA has reason to believe that entry will be refused, they can go to court and seek a warrant.
Warrant. So now we're getting really serious.
Yes, we are. A warrant gives OSHA the legal authority to enter a workplace, even if the employer isn't happy about it.
All right. I'm curious about the scope of the inspection. If OSHA gets a warrant, does that mean they can just look at anything they want?
That's a really important point.
Yeah.
And the answer is no.
Okay.
The scope of the inspection allowed under a warrant depends on the type of warrant they obtain.
Okay.
There are limited scope warrants, which are used for specific situations like complaints, referrals, or accidents.
Okay.
These warrants restrict the inspection to the area or the conditions directly related to the complaint or incident.
So if someone filed a complaint about a specific hazard, like a faulty piece of equipment, they can only look at that piece of equipment.
Exactly. The warrant would clearly define those boundaries.
Okay.
But then you have broader warrants, which, as the name suggests, cover a wider scope.
So I imagine those are a lot harder to obtain.
They are. To get a broader warrant, OSHA has to convince a judge that there's a good reason to believe that violations are widespread throughout the facility, not just limited to a specific area or issue.
So they need to have some pretty concrete evidence.
They do. Like patterns of violations in the OSHA 300 logs, statements from employees, or even observations they made in plain view that suggest broader safety issues.
So those 300 logs, those injury and illness records are pretty important.
They are a piece of the puzzle.
Okay.
But here's a key takeaway.
Okay.
OSHA 300 logs alone are typically not enough to secure a broader warrant.
Okay.
They need additional solid evidence to back up their request.
Okay.
They need to show that there's a legitimate reason to believe that violations are happening on a larger scale.
So it's not just about keeping your 300 logs clean.
No.
It's about actually having a safe workplace.
Exactly. The logs are a reflection of your overall safety program.
Right. Okay. So who actually goes to court to get these warrants?
That's handled by the area director.
Okay.
But they don't go alone.
Okay.
They work closely with the regional solicitor, who's the legal expert within OSHA's regional office.
Right.
The area director gathers all the evidence they have. The 300 logs, employee statements. Anything that supports their case. And they work with the regional solicitor to present that information to a judge to make their case.
So it's a team effort.
It is.
Okay. Well, it sounds like employers really don't want to end up in a situation where OSHA is pursuing a warrant.
It's definitely a situation to avoid. And that's why understanding these legal tools and procedures is so important for safety professionals.
Right. Knowledge is power.
It is.
Okay, so we've covered subpoenas. We've covered warrants, all about OSHA trying to get information and access.
Yes.
But I want to shift gears a little bit and talk about what happens after an inspection, after those citations have been issued, or maybe not. What happens on the legal side of things then?
Well, that's where we enter a whole new chapter of the OSHA legal saga.
Okay.
And it's filled with its own set of rules, deadlines, and potential pitfalls.
Okay.
One of the most important things for employers to understand is the notice of contest.
Okay. What is a notice of contest?
It's essentially an employer's opportunity to formally challenge OSHA's findings. If they believe a citation is inaccurate or unfair, or if they disagree with the proposed penalties, they can file a notice of contest. But here's the catch. They only have 15 working days from the time they receive the citation to file that notice.
15 working days. That's not very long.
No, it's not.
So let's say an employer misses that 15-day deadline. and they try to file a notice of contest. What happens?
Well, OSHA will typically inform the employer that the citation has become a final order, meaning it's legally binding.
Gotcha.
And if they still want to challenge it, they have to take a different route.
What's that different route?
They would need to contact the Occupational Safety and Health Review Commission. Or OSHRC for short.
OSHRC?
I know, right?
Another acronym?
Another one, but OSHRC is a pretty important player in all of this. They're an independent federal agency that acts like an administrative court. Specifically for OSHA cases.
So they're like the judge for OSHA disputes.
Exactly. They handle those disagreements between OSHA and employers. And make decisions about citations and penalties.
So if an employer files a timely notice of contest, the case goes to OSHRC.
That's right. The area director who issued the citation sends the case over to OSHRC. Along with all the relevant documents.
And then what?
Once the case is with OSHRC, it enters what's called contested case processing, where everything is filed electronically. And there are specific procedures for handling these contested cases to ensure fairness and due process for both OSHA and the employer.
So there's a set process.
There is. And that brings us to another important piece of the puzzle commission procedures.
All right, hit me with these commission procedures.
Great. So essentially, there are two levels of adjudication within OSHRC. The first level is before an administrative law judge, or ALJ. The ALJ conducts a hearing, reviews all the evidence presented by both sides, and then issues a written decision.
So it's like a mini trial.
Exactly. And if either party disagrees with the ALJ's decision, they have the right to appeal it to the second level, which is the full commission.
So you've got like two levels of judges.
You do. And the commission procedures are designed to ensure that both sides get a fair hearing, and that the final decision is based on a thorough review of all the evidence.
Makes sense now within those commission procedures?
Yes.
There are two types of proceedings, right?
There are.
Conventional and simplified.
Yes.
What's the difference?
So conventional proceedings are more formal, involving things like legal pleadings discovery, and those detailed post-hearing briefs that lawyers love to write. Simplified proceedings, on the other hand, are simpler. They're designed to streamline the process for more straightforward cases.
So if it's a relatively minor citation with a small penalty, they might opt for the simplified.
Exactly. And either party can request a simplified proceeding. Or the ALJ can decide to use that format. Based on the complexity of the case.
That makes sense. But even with simplified proceedings, I'm guessing there's still a lot of back and forth.
There's a process called discovery. Where each side can request information and evidence from the other side. This is where things like interrogatories, requests for production of documents, and even depositions come into play.
Depositions like under oath.
That's right.
Wow.
And if a deposition is requested, OSHA will send an attorney from their solicitor's office to represent them.
So they have a whole legal team.
They do.
Wow. This is starting to feel a little overwhelming.
I understand it can definitely feel like drinking from a fire hose, especially if you're not a lawyer. But that's why we're doing this deep dive to break it down into manageable chunks and empower safety professionals with the knowledge they need.
Exactly. And even though this legal framework might seem intimidating, it's ultimately designed to protect workers.
It is.
And ensure safe and healthy workplaces.
Absolutely. So we've covered subpoenas, warrants, the whole contest process. It's clear that the legal side of OSHA inspections can get pretty complex.
It can.
And we've only just scratched the surface.
We've only just begun.
We'll be back for part 2 of this deep dive, where we'll delve into even more legal intricacies, including what happens when an employer decides to thumb their nose at a final order.
Talk about high stakes.
Until then, stay safe.
Stay compliant. And most importantly,
stay informed.
Stay informed.
And remember, a deeper understanding of these legal processes can be your best defense when it comes to navigating OSHA inspections.
We'll see you back here soon for part 2.
Welcome back to our deep dive into the legal side of OSHA inspections.
Picking up right where we left off, exploring this fascinating and sometimes intimidating world of OSHA's legal authority.
Right. Last time we talked about subpoenas, warrants, and that notice of contest process.
But today, we're going even deeper.
Yes.
What happens when an employer says, nope, not doing it?
Right. Those situations where an employer ignores a final order.
Okay, yeah, that sounds like a recipe for disaster.
It can be.
OSHA goes through all that trouble
to
issue a citation.
Right.
And it becomes final.
Right.
They're not just going to walk away if the employer ignores it.
No, they're not.
Okay, so what happens? What are the consequences of noncompliance?
Well, one of the most powerful weapons in OSHA's arsenal is what's called a Section 11B summary enforcement order.
Section 11B, that sounds pretty serious.
It is.
Break that down for me.
So in a nutshell, it allows OSHA to go directly to a federal court to enforce a final order that's been issued by the Review Commission.
So they're like going straight to the top?
They're bypassing all those administrative channels.
Wow.
And going straight to federal court.
So employers, I bet, get a little nervous when they hear that.
They do, and there's a good reason for that.
Yeah.
Because if an employer violates a court order, they can be found in contempt of court.
Contempt of court.
Yeah. And the court has a range of options for penalties.
Like what?
We're talking daily fines.
Okay.
Reimbursement of OSHA's legal costs, and even potential jail time.
Jail time. Wow.
For company officers who willfully disregard the court's order.
Okay, so now we're talking about personal liability.
Yes.
Not just company fines.
That's right.
That really raises the stakes.
Absolutely.
Okay, so I'm guessing OSHA doesn't do this for every single case.
They don't.
Where an employer fails to comply.
Right.
How do they decide when to pursue this Section 11B?
Well, they don't take this step lightly.
Okay.
It's typically reserved for situations where there's a clear and persistent pattern of noncompliance.
Okay.
Or where the hazards are so egregious that they pose an immediate and serious danger to workers.
So either they're repeat offenders or they're just blatantly putting their employees at risk.
Right. The Field Operations Manual actually outlines some specific factors that OSHA considers when deciding whether to seek a Section 11B order.
Okay.
For instance, they'll look at the employer's overall history with OSHA. Have they been cited for similar violations in the past?
So if they have a track record of ignoring safety regulations, that's not a good sign.
No, it's not.
Okay.
They're also going to scrutinize the employer's actions and statements.
Okay.
Are they showing a genuine commitment to fixing the problem? Or are they giving off vibes that they're not taking the situation seriously?
So if OSHA hears an employer saying something like, we're not going to waste money on that.
Right.
That's not a good thing.
No, it's not. That kind of dismissive attitude is a surefire way to land on OSHA's bad side.
Right. And of course, the nature of the violations themselves.
Exactly.
Repeated violations of the same standard.
Right.
Especially if those violations are classified as serious.
Absolutely.
Okay. So OSHA decides to pursue this Section 11B.
Right.
What happens next?
Well, OSHA has to present their case to the court.
Okay.
And convince the judge that the employer is in violation of a final order and that a summary enforcement order is necessary to protect workers.
So I imagine the documentation is really important here.
It is. Documentation is king when it comes to these legal battles.
Right.
OSHA needs to be able to prove that the employer received the citation, that it became a final order, and that they just decided to ignore it.
So all those documents we talked about in part 1.
Exactly.
All that's going to come into play.
Yes. And any other evidence that supports their case.
Right.
Things like photographs,
yeah,
employee statements, even expert testimony.
Okay.
All of that can strengthen their position.
So the court sides with OSHA.
Okay.
Issues the order.
Right.
Is that the end of it?
Not quite.
Okay.
Once the court issues the order, OSHA will typically conduct a follow-up inspection.
Okay.
To make sure the employer is actually complying with the court's directives.
So they're going to go back to the facility.
They are.
And make sure that they're actually fixing things.
Right.
And if they're not?
Then OSHA can go back to the court.
Okay.
And request further action, potentially including those contempt of court penalties.
Right. The fines, the legal fees.
Exactly.
Even jail time.
It can happen.
Wow. Okay, so it's really not a good idea to ignore those orders.
No, it's not.
All right, so we talked about employers who just flat out refuse to comply.
Right.
What about an employer who maybe they're willing to comply,
okay,
but they need a little more time?
Mm-hmm.
Maybe they have to order a specific part or hire a contractor. Mm-hmm. Does OSHA have any flexibility in those situations?
Yes, they do.
Yeah.
There's a process for requesting more time.
Okay.
To abate a violation.
Okay.
It's called a petition for modification of abatement, or PMA.
PMA.
Okay.
Another acronym.
I know, right? But PMAs are actually a pretty important tool for both employers and OSHA.
Yeah.
They allow for a more collaborative approach to addressing hazards, especially when abatement might take longer than the original time frame.
So if an employer needs more time to install a new engineering control or revamp their training program, they can file one of these PMAs.
Exactly. But it's not just a matter of sending OSHA a note and saying, hey, we need more time.
Right.
The employer has to provide a compelling justification for the extension.
Okay.
And demonstrate that they're making a good faith effort to abate the hazard.
So they have to show OSHA they're serious about fixing it.
Yes. They need to have a solid plan in place.
Okay. So what kind of information does an employer need to include in a PMA?
Well, the Field Operations Manual provides some guidance on this.
Okay.
First and foremost, the employer needs to be very clear about which violation they're requesting an extension for.
Right.
They can't just say, give us more time for everything.
Right.
They need to propose a new abatement date that's realistic and achievable.
Okay.
And they need to provide a detailed schedule outlining all the steps they're going to take to achieve abatement by that new deadline.
So they need a plan.
They do.
OSHA's not just going to give them extra time just because... Okay, and I imagine safety has to come first.
Absolutely.
OSHA's not going to grant an extension if it means putting workers at risk.
Right. The employer has to demonstrate that they're taking steps to protect their workers while they're working towards abatement.
So maybe that means implementing some temporary control measures, increasing monitoring or supervision, providing additional training.
It's all about demonstrating that commitment to both compliance and worker safety.
All right, so the employer sends their PMA off to OSHA, who reviews these.
The area director.
Okay.
The same person who issued the original citation.
So it goes right back to them.
Yes, and they have the authority to approve or deny the PMA.
Based on the information?
Based on the information the employer provides.
Okay, so what if the area director says no?
Well, the employer has the right to contest the denial.
Okay.
Just like they can contest the original citation.
So we're back to that notice of contest process.
We are.
Potentially ending up before an ALJ or even the full commission.
It could happen.
But hopefully it doesn't have to go that far.
Hopefully not in most cases. Employers and OSHA are able to work out these PMA requests.
Right. Without having to go to court.
Without having to go to a full-blown legal battle.
It seems like it's in everybody's best interest to try to find a solution.
It is. It saves everybody time, money, and resources.
Right.
And ultimately, it helps ensure that workplaces are safer.
This whole conversation about PMAs really highlights the importance of communication.
It does.
Between employers and OSHA.
Communication is key.
Yeah.
When employers are proactive and transparent and genuinely committed to safety, it really helps.
Yeah. It paves the way for a much more cooperative relationship.
It does.
All right. Now, before we wrap up this part of our deep dive, I want to go back to something you mentioned earlier about a well-documented case file.
Yes.
It seems so important.
It is.
To have all your paperwork in order to navigate these legal issues.
Having a comprehensive and well-organized case file can be your best defense.
All right, so what should be in that case file?
Well, first and foremost, a copy of your written safety and health program.
Okay, so your plan.
Your blueprint for a safe workplace.
Right.
But it's not enough to just have the written program.
Right.
You need to be able to show that you're actually putting those words into action.
So it's about action, not just words.
Right. And that's where those records come in.
Okay.
You need to be keeping meticulous records of your safety training, including dates, topics covered, and who participated.
So training logs, sign-in sheets, all of that.
Exactly.
Okay.
You also need to keep detailed records of your hazard assessments.
Okay.
What hazards have you identified? What steps have you taken to control them?
Right.
When did you last review and update those assessments?
OSHA wants to see that you're on top of it.
They do.
Okay. What else?
And don't forget about your inspection records.
Okay.
You need to be conducting regular inspections.
Right.
Documenting your findings and tracking any corrective actions you've taken.
So OSHA sees that you're proactively looking for hazards.
Exactly.
And addressing them.
It demonstrates a culture of safety.
Right. And of course, those injury and illness logs.
Right. Those are non-negotiable.
Those are important.
They are. And if those logs are showing a pattern of injuries or illnesses related to a particular hazard, that's a sign that you need to step up your game.
Okay. So we've got all those foundational documents.
Right.
The program, the training records.
The hazard assessments.
The inspection logs. What about documentation related to specific incidents.
Right. That's another crucial piece of the puzzle.
Okay.
You need to be documenting all incidents.
Even if they seem minor?
Yes, no matter how minor they might seem.
Why is that?
Well, those seemingly minor incidents can provide valuable insights into potential hazards and help you prevent more serious accidents down the road.
So it's all about learning from your mistakes.
It is, and if OSHA comes knocking, having those incident reports can really help.
Okay, so what should we be including in those reports?
You want to be as thorough as possible.
Okay.
Get the date, time, and location of the incident, a detailed description of what happened, including any contributing factors, get the names of any witnesses, and don't forget to document any injuries, and the steps you've taken to prevent a similar incident.
And photos, I imagine, are a good idea, too.
A picture's worth 1,000 words.
Right.
And photographs can be incredibly valuable.
Okay.
Especially if there's a dispute later on.
So this is a lot of documentation.
It can be a lot of work, but trust me, it's worth the effort.
Okay.
A strong case file can protect you from liability, potentially reduce your insurance premiums, and most importantly, it can help you create a safer workplace.
So a lot of benefits.
There are.
Okay, we've covered a lot of ground in this episode.
We have.
The consequences of ignoring a final order.
Right.
The ins and outs of PMAs and all this record keeping.
Yes. The legal side of OSHA compliance can get very complex.
It can.
But hopefully we've shed some light on the key concepts.
Hopefully.
And given you some strategies.
And this is just the tip of the iceberg.
It is. There's so much more to explore within OSHA's legal framework.
Right.
But we've given you a solid foundation.
Okay.
Don't worry, though. We'll be back for the final part of our deep dive.
Yes.
Where we'll uncover even more legal secrets.
Okay.
And strategic tips.
I like it.
To help you build a rock-solid safety program.
Sounds good to me.
But until then, remember, knowledge is power.
Knowledge is power when it comes to OSHA. Compliance knowledge can mean the difference between a safe workplace and a legal nightmare.
Stay safe out there, and we'll see you back here for part 3.
Welcome back, safety pros, to the final part of our OSHA legal deep dive.
We've been through a lot together.
We have.
Subpoenas warrants those moments when an employer says, I'm not doing it.
Yeah, we've covered some pretty intense stuff, but before we close the book on Chapter 15, there's a few more things we need to talk about, and today we're focusing on a specific type of OSHA inspection.
Okay.
The follow-up.
The follow-up.
Yeah, because an initial inspection is really just the beginning of the story.
It is.
There's usually a follow-up to make sure that those hazards are getting fixed.
Right.
And those citations are being taken seriously.
Absolutely. Follow-up inspections are really crucial.
Okay, so let's talk about what triggers a follow-up inspection.
Okay.
Is it automatic after every citation, or does it depend on the severity?
Well, the answer, like so many things with OSHA, is it depends.
No.
In some cases, a follow-up is pretty much guaranteed.
Okay.
For instance, if an employer receives a citation for a serious violation, OSHA is almost always going to conduct a follow-up.
Okay. And serious violations are those ones that could result in death or serious harm.
That's right. They want to make sure that those hazards are addressed.
Right, to protect workers.
Right.
What about those less serious violations?
Well, a follow-up might not be automatic, but OSHA can still conduct one if they have any concerns about the employer's commitment to fixing the problem.
So even if it seems minor, they shouldn't assume they're off the hook.
Exactly. And here's another thing. Even if the employer has corrected the initial violation, OSHA might still do a follow-up to see if they've implemented any preventative measures.
So it's not just about fixing the problem.
Yeah.
It's about making sure it doesn't happen again.
Exactly. They're looking for that long-term commitment to safety.
Okay, so we know it can trigger a follow-up.
Right.
But what about the timing of these follow-ups?
Well, the timing is kind of like choose your own adventure. For those serious violations that we talked about.
Yeah.
The follow-up usually happens pretty quickly.
Okay.
After that abatement date on the citation.
So if the citation says they've got 30 days to fix the problem,
right,
OSHA could show up on day 31?
They could.
Okay, but what about those situations where an employer gets an extension?
Okay.
Like with a PMA, that petition for modification of abatement.
Yes. If a PMA is granted.
Yeah.
The follow-up inspection typically happens after that revised date.
Okay.
But OSHA still has the power to inspect sooner.
Okay.
If they have any reason to believe the employer isn't doing what they said they would.
So even with an extension, they shouldn't relax.
Right. It's like that old saying, trust but verify.
Okay, so Bottom line is employers should always be prepared for a follow-up.
They should.
All right, so we talked about what triggers a follow-up.
Right.
We talked about the timeline. Now I'm wondering about the scope.
Okay.
Are they just focused on the original violations, or can they look at other things?
So in most cases, follow-up inspections are really just focused on those cited violations.
Okay.
But here's the catch. If during the inspection, the inspector sees other hazards, they can expand the scope.
So even if you fixed the first problem, you could end up with more citations.
You could.
That's a good reason to have a really good safety program.
It's about creating a workplace where safety is part of everything you do.
Yeah, not just a reaction to an OSHA citation.
Right.
Okay, so let's say the worst happens.
Right.
An employer fails a follow-up inspection. What happens then?
Well, the consequences really depend on the severity of the violations.
Okay.
And the employer's history.
So if it's minor and they've got a good record, maybe they get a warning.
That's possible.
Okay.
But if it's serious or if the employer has a history of problems, things can escalate.
Okay.
OSHA is likely to issue what's called a failure to abate notice.
Failure to abate, that doesn't sound good.
It's not.
Okay.
It means the employer hasn't corrected the violation.
Right.
And now they're going to face additional penalties.
So on top of the original penalty?
On top of the original penalties.
Wow, okay.
And those failure to abate penalties can really add up because they often accrue on a daily basis.
So the longer they wait, the more it's going to cost them.
Exactly.
And in some cases, OSHA might even refer the case to the Department of Justice.
They could.
For criminal prosecution.
That's usually reserved for the most egregious cases.
Right.
Like where a worker was injured or killed.
Okay, so these follow-up inspections are serious.
They are.
And employers should take them seriously.
Absolutely. And it's not just about avoiding those penalties.
Right.
It's about worker safety.
Right.
They want to make sure that those hazards are corrected.
Exactly. And employees are protected.
Right.
This whole conversation has really highlighted the importance of being proactive.
It has.
It's not just about reacting to OSHA.
No, it's about having a good safety program from the start.
Yeah. Making safety a part of your workplace culture.
Exactly. And at the end of the day, it's about protecting your employees.
Well said. That brings us to the end of our 3-part deep dive into Chapter 15.
It does.
We've covered so much.
We have.
From subpoenas and warrants to follow-up inspections.
It's been a lot.
It has. Hopefully we've given you the information you need to navigate all of this.
I hope so.
And remember, this is just the beginning.
Right.
We encourage everyone to look at the source material.
Yes.
Explore these procedures in more detail.
And stay up to date.
Stay up to date.
Because OSHA is always changing.
Yeah. And never underestimate the power of knowledge.
Absolutely.
When it goes to safety, knowledge can save lives.
It can.
So stay safe out there, keep learning, and we'll see you back here soon for another deep dive into the world of safety and health.